British Society of Criminology's Green Criminology Research Network event of the year. I'm not going to talk too long, but I'm delighted to welcome as our speaker Dr. Oluwabusayo Wuraola, who is, and apologies if I have mangled your name, given how long I've known you, who is a lecturer in law at my institution, Anglia, Ruskin University, and does some fascinating work on rights of nature and rights of ecosystems and issues around legal personhood. So Oluwabusayo is going to talk for somewhere between 30 and 45 minutes, we think, and allowing some time for questions. I'm going to record this session, and if you can put any questions in the chat, rather than sort of interrupt, and I'll call on people for questions when we get to the end. So over to you to share your slides.
Thank you very much for having me, and I'll try to share my slides now. Can you see my slides?
Yep, I can see those. Yeah.
Okay, so hi everyone. I'm Oluwabusayo Wuraola, and I am an environmental justice enthusiast, I would say. I love doing research in relation to environmental justice, health jurisprudence, and particularly the rights of nature. And I remember being very keen about the rights of nature in 2017. And since then, I've been trying to look at how this would actually work to help prevent environmental harm and bring about environmental justice in particular. So today I'll be talking about how rights of nature helps to prevent environmental harm. Does it actually do that? You know, the rights of nature prevent environmental harm, or is it just symbolic? Do we just have the rights of nature for the sake of having rivers, forests, and other natural entities having rights? Is it symbolic, or does it actually do what it's supposed to do, bring about environmental justice and actually also prevent environmental harm? So, well, I wouldn't say as we all know, maybe as some of us know, we've had recent grants of rights of nature. We've had grants in Ecuador, Colombia, New Zealand, and so many other countries. Even in the UK, we've had the recognition of the rights of nature within the district council of Sussex and in relation to the River Ouse. And, you know, this has actually helped to give people some form of awareness about the rights of nature and its growing, the prevalence of it, you know, that it's actually increasing, granting rights of nature in the world generally now. At some point, I was able to keep pace with the different grants of nature or the different grants of rights to rivers, rights to forests and, you know, parks, etc. But right now we have a lot of them, and, you know, I just get to wake up sometimes and I say, oh, this particular natural entity has rights in this country, and, you know, it works for me because I'm always happy about that. So I'm going to talk about how these rights of nature actually help prevent environmental harm in some countries, particularly Ecuador. I'll be emphasizing on Ecuador. And I would also try to discuss what some scholars have said in relation to the grant of rights of nature, because some actually do not agree with it. They feel, well, why have rights of nature when we already have a plethora of environmental laws that actually help to deal with environmental harm and bring about environmental justice? So they feel, well, it's not practicable to have that. It's not necessary. It's not worth it. So we're going to have some of these arguments as well within the discussion today. And we'll look at the different rights as well, what it means to have the rights of nature. What does it entail? This, of course, includes the rights to exist, to flow, to be restored, and things like that. So with this, we would then consider some cases, particularly in Ecuador, following the grants of rights of nature, and see how this has actually helped to have a great impact or to advance the effectiveness of environmental justice and to actually prevent environmental harm. Okay, so yeah, this is like the overview of what we'll go through today. Okay, to start with, the emergence of rights of nature, just to give a little background or refresh the memory of those who already know about the rights of nature on what it is about. The rights of nature came up in order to it's seen as an alternative to environmental protection, in the sense that it actually gets to be granted to rivers that have actually been polluted because there has been, you know, the failure of the environmental regulations or the environmental laws in some areas, in some countries, to protect these rivers. So it's seen as an alternative to protect these rivers because at the same time, you know, within environmental justice, some of these laws have not actually been enough to protect the rivers or to prevent environmental harm in the sense because there's usually that prioritization of economic development or some human interest over the rivers. So it's in some countries as well, it's actually difficult to bring about sufficient interest in the river to be able to stand in for the river in the court of law to get justice. So this is seen as an alternative and as well seen as a main platform for rivers to actually, or nature generally, to actually have their own rights and to be protected. And with this, it doesn't only help to protect the intrinsic value of nature, it also helps to ensure that humans have the continuity of the value they get from the rivers, the instrumental, the rivers being having instrumental value and the continuity of having a right to a healthy environment. So it's the grant of the rights of nature underlines nature's intrinsic value, and it also advocates for the nature's protection beyond its usefulness to humans. So, and overall, this actually brings about having both ecologically effective and sustainable legal regimes, which actually aim to regulate human behavior to positively respond to conservative earth governance principle as well. Okay, so thinking about the rights of nature, ecosystems having legal rights, one would expect that once they have legal rights, then of course there should be um, difficulty in committing environmental crimes or bringing about environmental harm. Environmental harm should be harder to cause. And so we then get to think about, okay, what rights actually helps to prevent these environmental harm? So if you say nature should have rights, what rights do they actually have? What are the mechanisms around the grant of rights of nature? And what would actually be the outcome? So if you think about the rights of nature, of course, in most jurisdictions that have granted the rights of nature, there's this. It's usually protecting the rights of the river, or of course, for example, the river, the rights to exist and to flourish, the rights of the river to flow, and of course, the right to be restored back to its existing state, which in some cases is actually very difficult to do that. And of course, the right of being represented in the court of law and having standing in the court of law to sue maybe companies who have actually polluted rivers and of course degraded the environment. So these are the rights, these are the common rights that get to be recognized with the grants of rights of nature. And the mechanisms surrounding this includes having standing to start with. Of course, we know that the river can be in courts to stand for itself. It has to be represented by different representatives. So in different countries, it could be guardians being appointed or representatives being appointed. And we're going to talk about Ecuador as well, with all persons having the right to represent nature. And of course, that may not actually work. That may not actually be practicable because with everyone representing nature, you wouldn't be able to tell whether they are going to represent their own personal interest or the interest of nature. So having standing to sue, having legal suits help to protect the environment. The awareness of the fact that, well, these rivers or these natural entities or ecosystems actually have standing, they can represent themselves. I think it's a mechanism to actually deter people from, causing that harm towards them, and it helps to protect them more. So the second one is injunctions. When court cases are being instituted, the court can then decide in favor of the party who is the victim to stop some actions in relation to that would lead to environmental harm, and or to ensure that precautions are actually taken to ensure that the ecosystem is actually protected. So yes, guardianship as well. So guardianship doesn't only include going to the courts to represent the natural entity or the ecosystems. It includes actually making decisions for them and on their behalf in different platforms or wherever the decisions have to be made. And we've seen this happen in New Zealand, particularly because the representatives, much more than even going to court to resolve issues, they try to have dialogues with the polluters and see how to resolve some of the issues in relation to pollution or harm to the Wanganui River, for example, and things like that. So this actually helps to know that yes, they help to make decisions and to ensure that the river is protected. So we also have restoration remedies as another mechanism, which comes with the grant of rights of nature. And thinking about this, you know, there are some pollution or degradation that cannot actually help to get the natural entity back to the initial state it was before the degradation. So what then can be done? Of course, restoration can be granted as a remedy, and this would definitely help to deter people, because if they have to pay for restoration or go through the process of restoring the natural entity back to the state it was, then of course that may be difficult for them, and it may act as a deterrence for others who have or are trying to attempt to degrade the environment. So so far there have been different outcomes, and I will discuss some of them very soon. With the grant of rights of nature or ecosystems having legal rights, there's been a halt in pollution. It has helped to stop pollution. It has helped to stop destructive projects and all that. Courts have actually asked potential polluters to have some form of environmental impact assessments to be able to ensure that the natural entity is protected. And of course, it has also brought about ecological restoration. So overall, there's a sense of having some form of prevention of environmental harm with the grants of rights of nature. And but at the same time, in some jurisdictions or in some countries, it's been seen as only symbolic. It's just there. The rights are just there. Not really effective and not really practical. It's just, one of those environmental laws as well. But of course, people get to be aware that this particular natural entity is has rights. Okay, so now thinking about that, it's very important to then consider the justifications before the grants of rights of nature. It's important to actually look at what these rights are about. We've already talked about the rights, the mechanisms of the grants of rights, and also the outcomes. But with those areas that actually had some form of symbolic rights of nature being granted. I think it's important to actually consider the ethical justifications, the legal justifications, and the governance justifications, to be able to tell what the basis of having the rights of nature is about, and to be able to work on ensuring that um, these purposes are actually achieved, and the grant of rights of nature are not just symbolic. So the treating ecosystems as legal subjects brings about seeing these ecosystems as not only as persons, with the grant of legal personhood, for example, you get to see the ecosystem or the natural entity as a person and not just property, because there's that human perspective or conception about nature being just property, and that's why they get to have some form of they get to see it as having only instrumental value rather than intrinsic value. So so once we are able to move from having the perception of ecosystems being just property, but of course being an entity with its own intrinsic value, and of course an entity deserving of its own good, not just its benefits to human, but the goods it actually has of itself. Okay, then this would help to ensure that all of these ethical justifications, all of these perspective are actually working in relation to how to ensure that there's protection of the rights of nature based on the fact that it has intrinsic value, and once it's granted rights, of course, there's that recognition, respect we have of nature having good in itself, and also the benefits it brings about beyond human benefits. It's not only beneficial to protect natural entities for human purposes, but also for the natural entity to have its own, intrinsic value protected, to have its own pristine nature, to have the right to float, the right to flourish, and of course having balanced use of the natural entity, not just use that brings about pollution or irreversible harm to the natural entity. Because if it's causing irreversible harm, then of course even restoration would not be possible, and it will cause damage to the intrinsic value of the river. So there are also legal justifications as purposes of having the rights of nature, and this includes having, of course, having rights, helps to, see the natural entity or the ecosystem as not just an object of rights, but a subject of rights. And like I mentioned before, this brings about legal standing in court. This brings about being able to be represented, and also brings about the prevention of environmental harm or the restoration of the ecosystem back to the state it was before degradation. We also have governance justifications as well. And of course, this brings about a shift from managing the harm to actually preventing and restoring harm. So with the position that rights of nature actually prevent environmental harm, we're able to see that it's not just symbolic, and it actually does what it says, what it's intended to do with governance, with people standing in for nature and or ecosystems, with people actually representing ecosystems as well. So and with the grant of rights of nature, um, of course, it's like I mentioned earlier, it's like an alternative to protecting the environment. It's seen as a pathway, another pathway to bringing about environmental justice, because it actually helps to, you know, um, get everyone engaged in trying to prevent environmental harm, and it does not only bring about, people appointed as guardians or representatives of ecosystems, as those who, work towards preventing environmental harm. It brings about involving communities, involving NGOs, and even citizens as well, with the awareness of the fact that there's that grant of rights of nature. So it helps generally to prevent the harm strategy, I would say. And earlier on there were no right when, of course, there was of course no rights of nature. There was that dependence on environmental laws and all that, but that's been seen to not be working. And with the grants of rights of nature, it brings about standing, and this could actually mean litigation, in relation to the fact that anyone who tries to pollute or degrade the ecosystems, of course, can be taken to court, and we have standing. But it also brings about some form of precaution as well. It strengthens some of the existing environmental laws already that we have, that talks about the precautionary principle and talks about the restoration of the environment to the state it was, and also helping to enhance the prevention of harm strategy, and also to ensure that government or the governance, or all of the representative bodies actually ensure that ecological interests are you know imputed in the routine decisions being had in relation to the environment. So it also brings about some form of planning, because the recognition of the rights of ecosystems of nature brings about, once there's that grant, then of course you have to plan for the protection of the rights of nature. So it helps planning, it helps budgeting, it helps enforcement priorities. And of course, the governance bodies, try to see how to ensure that decisions are made in consideration of the ecosystem. So this actually helps overall. All of these definitely help to prevent the rights of nature. So we have, so far, I'll discuss about 4 types of grants of nature. And the first one is the constitutional rights of nature. They're like the models in different countries. So each country does not have a particular kind of model. The grant of rights of nature could actually be via constitutional rights of nature, like we have in Ecuador. It could also be via um, statutory personhood, like we have in New Zealand, where the Whanganui River Act 2017 had the legal personhood of the Whanganui River. It could also be by judicial declarations, where either in constitutional courts or other courts within North America and Colombia, particularly with the Constitutional Court recognition. And it could also be by local ordinances, charters, council recognition, etc. Like in the UK, now we've had so many councils, district councils, considering the recognition of the rights of nature as well. So all of these help to show that there are different ways, the different legal systems are trying to see how to prevent environmental harm by granting the rights of nature. So all of these work together to ensure that there's constitutional rights, and these rights of nature are actually protected within the constitution. For example, in Ecuador, which is the first country to have the constitutional rights of nature. We also have Uganda in Africa, who also has which has a constitutional rights of nature within its constitution as well. So in relation to this, I'll just take some examples: Ecuador, New Zealand, and Colombia. And like I said before, with the Ecuador one, there's that constitutional innovation, and you would see other countries trying to follow that, like Uganda and things like that. But with the grant of rights of nature within the constitution in Ecuador, it is realized, it is observed that with that grant, no particular representative was appointed, but the Constitution actually mentions that all persons can actually stand in for nature. Interestingly, in as much as there's that all person kind of representative mechanism, you would think that, it would not work, having all persons. But interestingly, in Ecuador, we've had quite a number of cases coming up and quite a number of people actually helping to put forward the rights of nature in courts to defend the rights of nature. Some have failed, some have been successful. And yeah, so we're going to look at some of those then. And we have New Zealand as well, with legal personhood of nature, with very strong representatives appointed from the community, from the indigenous community of New Zealand. And in New Zealand particularly, there were two human faces appointed for the Whanganui River grant of legal personhood. And these representatives have actually been helping to see how to protect the river against degradation. So we also have Colombia and ecological justice by Colombia having the constitutional court recognition of the rights of the Atrato River and the Amazon rainforest. And this actually helps to see how the different platforms, we have different models in different countries. So yes, talking about Ecuador again, there have been different lawsuits, like I mentioned earlier. Some have failed because of the fact that it was noticed, it was observed that the personal interest of those who instituted the action um, was put forward instead of the personal interest or property interest they had was actually put forward instead of the interest of nature. So they, in the process of standing for the rights of nature, they had their own personal interest, and that didn't actually work. So the outcomes are mixed. Some cases actually succeed, others fail. But of course, when others failed, you would realize that it's usually as a result of some political or economic issues or prioritization of political or economic interest. Okay, so yeah, most of it, as some have actually been around mining. We've had mining conflicts and all that. But you would notice that recent decisions from Ecuador actually show stronger judicial willingness to apply the rights of nature and to actually take precautions as well. So in lawsuits, for example, recent lawsuits, I think in 2025, there was a particular lawsuit about the marine ecosystems, and the court was able to ensure that there were more legal protections. And this has actually inspired different judges or the courts to grant further rights of nature. So it's actually very practicable in Ecuador, having the rights of nature. It helps to prevent environmental harm. We have some cases after the grant of rights of nature within the Constitution in 2008. And this includes the Konai Indigenous Movement and Community Water Council's case. And this has actually challenged the 2009 mining law on the basis that it violated the Constitution's right of nature. And, with this, you would see that there's that preventive prevention of environmental harm strategy with the decision. And the decision came up with having effective environmental impact assessment procedures by which mining can actually be made constitutionally and compatible with rights of nature, so that there's that environmental harm prevention logic. And it also brings about procedural enhancements by screening, bringing about mitigation and things like that. So it has actually helped to, practically prevent environmental harm in the sense that, it has brought about in enhancing the procedures. It has brought about stronger decision making, even by the courts, and ensuring that, of course, the rights of nature is not only symbolic but actually practical. So we also have other cases that have gone to court, a collection of indigenous movements, environmental and human rights NGOs as well, and community organizations taking defending the rights of nature and seeking, for example, in that case, seeking suspension of the um, mining project, the Kando mining project, and this there was the allegation that it actually risked removal of ecosystems, and a thorough environmental impact assessment was also requested to be done. But in this particular case, despite the fact that it was unsuccessful, it also demonstrates how rights of nature is being used to force the court to confront ecosystem scale risks and habitat removal, extinction risk, and to definitely argue for stronger assessment. So this actually gets to show how rights of nature can be, subordinated to development narratives, and but at the same time, it actually helps to, ensure that there's that prevention of environmental harm. Another case is the collection of 16 community members case, and against the director of the company, of a particular company, and the director is Yuan River Denera. So the community alleged that there was some form of machinery from a pork processing plant, which harmed the flora, the fauna, and the aquatic systems. And the claim was framed as human rights to health and a clean environment, but the judge treated it as a potential right of nature violation. So this actually shows that, with the grant of right of nature, there's that ongoing monitoring, there's the ongoing auditing, which brings about prevention. They get to detect the potential harm and try to control the pollution pathways before they get to be escalated. So it illustrates how judges actually upgrade the human health pollution disputes into a right of nature centered kind of remedy in order to widen environmental protection beyond what was existing before. So we have the Ministry of Interior lawsuit as well, and these lawsuits brought about seeking authority for precautionary measures as well to combat unauthorized mining and mining that actually violated the rights of nature, particularly water rights, court approved and other armed forces and agencies to control illegal mining as well. So this would, I'd say is one of the clearest harm prevention, environmental harm prevention cases, because it deals with taking precautionary measures, having precautionary authority, enforcement operations that can stop pollution at source, at the initial phase, especially mercury, river impacts typical of illegal mining. And it also helps to ensure that this the concerns in relation to the environment are actually tackled before the pollution. So because of time, I'll just run through what we have in Colombia and New Zealand. In Colombia, there have actually been court orders as well that have actually tried to see how to ensure that there's the protection of the environment after the grant of rights or of the Atrato River. And it has also brought about implementation that has actually generated institutional momentum. It has actually ensured that there are governance and guardianship measures. There are commitments to restoration and remediation, and there's that institutional coordination requirements as well. So the implementation of the rights of nature has actually helped to also prevent environmental harm. Though sometimes the prevention of environmental harm is actually hard, because some of the harms are tied to illegal mining, violence, and weak state capacity. But when court orders are actually strong and they are actually effective, then this helps where, sometimes the enforcement personnel are absent or threatened, or, some other issues actually come into place. So in New Zealand, we've had, I'd say no case yet, but I would, you know, give credit to the representatives or that have been appointed to protect nature in New Zealand. They've actually ensured that disputes are resolved even at the dialogue level. They try to, I wouldn't say it's like an alternative dispute resolution means, but they've actually tried to see how to talk through some of the problems and try to handle the disputes through dialogues with river guardians. And these representatives also help to participate in decision making that affects the river, and they help to limit the implications of degradation towards the Wanguni River and the grants of rights to Te Awa Tupua. So this has actually helped to also, bring about the prevention of environmental harm. But of course, there are criticisms of the rights of nature, like I mentioned earlier. Some have actually argued that it's not practicable, and the arguments are that, humans and nature are interdependent on each other, and there's no new concepts of law that is smooth sailing, and well, I'd say the rights of nature proceedings can, seem impracticable, but or especially when there is when they're actually unsuccessful. But that doesn't mean that, it has not helped in a way to ensure that there are stricter measures or precautionary measures that are taken in dealing with nature or the environment. So, but of course, there's the argument that rather than having obligations or owing obligations to nature per se, there should be meaningful environmental responsibility being pursued through rights and protections for human-led environmental organizations and things like that. So we've had so many criticisms of the rights of nature, particularly because some have actually felt that they would not bring about any change. They're just symbolic, and we have existing environmental laws that can protect nature without having new laws. And other criticisms by Sachs as well, saying that the rights of nature movement is undoubtedly ambitious, and it may not deliver on its promises. So yeah, these criticisms are being taken note of. But at the same time, I think what really makes the difference is when we actually see the practical aspect of things and the rights of nature being effective in the countries where there's been actually the grant of rights of nature, and try to study. So this is, I would say, still a work in progress. We can't know yet because some of these grants are actually very new. And, of course, people have said, do we actually need the rights of nature? And yeah, but I would say again, it's important to have a think about the justifications, the purposes for having these grants of rights of nature, to be able to tell whether or not, it's actually achievable, or, how to take it from being symbolic to ensuring that it actually brings about the prevention of environmental harm. Because, I'd say if we say the rights of nature is effective, that means that we have clear guardian representative with authority. They know what they're doing. They know what they're supposed to do. Not just, someone being appointed, or a symbolic person being appointed, or persons being appointed, but people empowered to act, not just ceremonial figures, and, people who actually consider, what would work best for the interest of the river, and not just for the interest of humans alone. At the long run, if the interest of the river is protected, the interest of humans are actually also protected. So budget monitoring as well, it brings about, having, if it's effective, then of course there's some form of budgeted monitoring, data access, prevention, in relation to detection and precautions being taken, and of course having injunctive reliefs in some countries, having restoration where needed, and also helping decisions to be made in consideration of nature. So, but if it's not effective, it would not be effective is if it's only symbolic. If it's symbolic, it's not effective. And this brings about having vague rights, no implementation plan, no enforcement capacity. Even when sanctions are made, the sanctions are low. Um, the regime of not having of having nothing has changed within the regime of having the grants of rights of nature, and different things like that would just make it symbolic and not actually doing what it's supposed to do, or ensuring that there's that prevention of environmental harm. So what's the way forward? I think the way forward would be to, for rights of nature to prevent environmental harm, the way forward would be to have clarity of laws, reforms, not just invalidation, clarity of procedures as well, training of experts to defend the rights of nature, and not just training experts to defend the rights of nature. If we just appoint people to defend the rights of nature without them knowing what they are actually meant to do, then of course it's not going to work. They wouldn't know what decisions to make. They would still prioritize their own personal interest as humans and make it anthropocentric rather than ecocentric. Training of judges as well. So judges have to be trained to be knowledgeable about what it entails to have the rights of nature, so that they will be able to make non-biased decisions. And also effective implementation would also help to ensure that, the rights of nature is not only symbolic, but it actually helps to prevent environmental harm. Thank you for listening. I hope I'm not going to be on time.
Excellent, thank you. You packed an awful lot into that, so well done. So I see people applauding in the audience. So as I understand it, what you're really saying is it's not just the notion of the rights of nature. It depends on how we implement the rights of nature and how well they are upheld by whoever the advocates are and also whoever the jurists are. So it's a kind of conditional consideration, and I think that's quite important. I'm just going to stop the recording and then just throw it open. We've got about 10 minutes. If there are any questions from the floor, you can either put your questions in the chat or raise your hand, and hopefully I'll see you and allow you to ask a question.